Justice Felix Frankfurter wrote in Malinsky v. New York that the history of American freedom is, in no small measure, the history of procedure. As crucial as the substance of the laws is the due process behind enforcement, which places the dirtiest criminal on the same level as the holiest man.
Due process is the bedrock of civil liberty, because it is the foundation that guards our rights from arbitrary governmental infringement. The idea of due process first emerged in Clause 39 of the English Magna Carta, which stated that no free man shall be captured or imprisoned or in any way destroyed except by the law of the land. Although this law of the land was not always upheld through English practice, the framers, whose own due process was violated, embedded this idea into the Fifth Amendment.
Due process is divided into substantive and procedural. Substantive due process ensures that the content of the law is constitutional. For example, in Bowling v. Sharp, the Supreme Court deemed the segregation in schools in the District of Columbia unconstitutional because it deprived African American children of their liberty in violation of the Due Process Clause.
Procedural due process deals not with the content of the law, but with the means by which the law is enforced. The Fourth through the Eighth Amendment delineate this procedure by prohibiting unwarranted searches and seizures, providing a fair trial, preventing cruel and unusual punishment, among other things. Procedural due process concerns, in the words of Bill of Rights scholar Akil Reed Amar, the danger that governmental officials might attempt to rule in their own self-interest at the expense of their constituents' sentiments and liberty.
Within the Constitution, due process can be found in Article 1, Section 2, Clauses 2 and 3. Clause 2 grants habeas corpus, while Clause 3 protects the people from bills of attainder and ex post facto laws. These protections are essential as they show the framers' initial attempts at protecting from overzealous government. Additionally, the Fourth Amendment's creation of incorporation revolutionized the idea of due process, as it applied the amendments to state level.
The rights guaranteed during a trial are meaningless without the enforcement of the rights before and after trial, such as the right to a grand jury and protection from cruel and unusual punishment. A trial cannot be fair unless the proper procedure was followed to acquire evidence.
The doctrine of the fruit of the poisonous tree follows this reasoning by inferring that any evidence acquired illegally throws the legitimacy of the case into question. Additionally, a decision would be rendered useless if a defendant's post-trial protections, such as that against double jeopardy, are violated.
While the right to counsel is an imperative right, we believe that the most important right granted to the criminally accused is the Sixth Amendment's right to an impartial jury. In the 1930s, the 9 Scottsboro boys accused of raping 2 women were convicted, despite having the famed lawyer Clarence Darrow representing them and a more than reasonable doubt as to their guilt.
Their all-white jury in Alabama could not be called impartial, and even with a well-qualified counsel, they were found guilty. The jury in itself an important check on governmental powers, as it provides the people with a direct role in that the government not only is supposed to be the protection for the accused, but also a method for teaching the people how to rule well. Although a truly impartial jury can never exist, a truly biased jury is one of the most threatening aspects of criminal justice.
Constitutional framer and namesake of this university, George Mason, stated that every society and all government ought to be calculated for the general good and safety of the community. A society cannot be free without free individuals. Due process honors and protects the individual freedoms that compose our society, and in doing so, creates the integrity of our justice system. Thank you.
339.
339?
What?
Dang.
Oh my
We need
goodness.
Maggie.
Oh yes! We get to add so much.
Or just add Maggie, she reads slower.
I mean, I don't think she adds 20
She
seconds.
puts big pauses.
Oh my
Okay.
god. 339.
Yeah, you wanna go?
Yes. Um, can a indigent defendant truly have his constitutional rights protected by a overworked, underpaid public defender? Explain your answer.
I don't feel like they could. I think that what the right to counsel as guaranteed to us today grants is a right, an equality of opportunity, but not necessarily an equality of condition. In other words, we all get the same. We all might get a lawyer, but it's not necessarily going to be the same. Like the lawyer is not necessarily going to do the same job each lawyer is going to provide a different quality of service because, as you said, some lawyers are going to be overbooked, overworked. So I don't think that our Constitution, as it is today, grants an equality, would adequately protect an indigent defendant. Sorry.
I don't know if this is what Mr. Randall wants me to say, but I should hope that our public defenders are acting with their civic virtue in mind and making sure that they perform an adequate job, because this person that they're protecting has his life and liberty at stake. So we need to ensure that they have an adequate counsel.
Going off what Ben said, it doesn't seem fair that an indigent defendant, would not necessarily have the same quality of a lawyer, but at the same time, it's the best system that we have right now, because I mean, people aren't born equal, so we're gonna have some lawyers that are better, some lawyers that are worse. So the only way that we could have everyone have an equally talented lawyer would be to have the same lawyer represent everyone, which isn't feasible.
How would you define competent counsel? What is the definition of competent attorney?
Under Nevada, I guess it would be considered if you pass the bar exam.
No, that's not true, but
Keep going.
Because it's, the whole idea is that states that these that these states, they set up certain exams or certain levels that someone has to surpass in order to be known as a lawyer or also a doctor, and this should be the level of competence. However, there have been cases, I guess, where people could cheat, or maybe the test is not as hard as it should be for lawyers.
There's also a Supreme Court case, which I will know by nationals, but not now. But it establishes what is an incompetent lawyer, which means that basically you can say that your lawyer is incompetent if you can prove that your case would have been significantly different if you had different counsel. And what was the other thing?
You have to prove that the end result of the case would have been different if your counsel had acted adequately, and that case was Strickland v. Washington.
Yeah, that one. So pretty much your representation is adequate unless it is proven to be inadequate. So.
Since you think a fair and impartial jury is so important, what do you think is the most important question that either a judge or an attorney can ask a potential juror on voir dire?
I think one of the most important things to establish biasness is to ask the jury whether or not they know the person or have been in any sort of contact with the subject matter, such as if the person on trial is on trial for killing a young boy, you wouldn't want a father who's had his son killed. That would create too much of a bias and wouldn't be fair for the defendant.
I somewhat disagree with my colleague, because there's not one question that's, I guess, more important than anything else. It's more of this series of questions in order to see if they have any sort of bias at all, because it's very easy for people to lie on just one question. So if you ask multiple questions, it's more likely for them to find out the truth. And maybe if they're trying to lie, then it's harder to keep your story straight or keep up a lie over a multiple set of questions.
It's a very common practice now for counsel to use jury consulting or specialists who help them pick a jury that would actually not be unbiased, but would be biased in certain ways that counsel might win the case. So I think that what's most important is that whole element is completely removed from the jury selection. I think that counsel needs to be focused on finding an unbiased jury that is going to make sure that justice is served and not that their particular side is victorious.
How much investigation into a potential juror's background should be allowed in the jury selection process? Since you think a fair and impartial jury is paramount.
When the jury gets down to a certain number, for example, if you get down to maybe around 15 jurors, plus or minus, give or take a few. Then there should obviously be maybe more extensive, maybe background checks of some
Stop.
sort.
Can you finish your sentence?
But I get to finish my thought. Yeah, as long as I want, unless I can answer his question.
Finish
Just
your
go,
thought,
just
finish
go.
your run-on sentence.
Just go.
Right.
And so, once you get around to this smaller number, you should look into more important facts to see if they're actually telling the truth. For example, the circumstance that my colleague brought up, well, that Catherine brought up about
That's so
a
funny.
father having his child murdered, for example, it would be appropriate for to search into this kind of important details that they may not have given freely out to the selection.
How's somebody gonna?
That's